Hey everybody, welcome to Victory Baptist Church Legal Clinic, the second edition. And so we are super excited about tonight. And so if you're joining us and those that are on our Facebook or our YouTube, as always, remember that we can see your comments, and I would love to add your comments into the stream so that we can get your questions answered and address any of your particular issues. So I'm super excited to have tonight attorney Tu Nguyen. And I'm telling you, we just had like our pre-conversation, and there's so much great information that's going to come to you guys tonight. We are talking tonight about wills and estates. So do you have a will? First question out the bat for all of you that are out there listening. Do you have a will? Is it even on your mind? Are you thinking about it? What are your plans? And so tonight, please get your questions ready. And again, I will read those out, and we'll be asking Attorney Tu Nguyen a little bit about wills and estates. So I'm turning it over to you, Tu. Tell us a little bit about yourself, and then let's jump into wills and estates.
Terrific. Thank you so much, Kelly, for having me today. I really appreciate the time that you're putting forth to put together this legal clinic for your membership. And once again, my name is Tu Nguyen, and I'm a practicing attorney in family law, estates planning, and also government benefits. I've been practicing for quite a while, and I have worked in the bankruptcy court, in the magistrate court, and also in the Office of Hearings and Appeals for the Social Security Administration. I'm here tonight to talk a little bit about what wills are and what the estate planning is about, and try to organize the documents that everyone should basically have in order to address these uncertain times during COVID. And I hope that this is informational and this is helpful to your membership. So let's get started with the presentation that I have.
Awesome.
So I'm the founder of the law office Tu Nguyen, PLLC, and I wanted to first talk about estate planning, and mainly about the protection of generational wealth. A lot of times, people think that estate planning or wills is really just for people who are very wealthy and have a lot of stuff. But anytime you have stuff, that is your asset. Any amount of stuff you have, you should protect it. And a lot of times people are under the impression that, oh, I just have this house, or I just have this car, or I just maybe have this ring, I just pass it down and it'll be okay. If you really want to be sure after your death that those things are passed the way you want them to be passed, then you want to have these documents set in place. So I've broken it into two sets. One is to first define what is estate planning. Okay, so estate planning, there's a lot of words up there. Estate planning is the process of anticipating the unexpected to make arrangements for events during your life, for the management of your estate, in the event that you become incapacitated during your life, and what you want to happen after your death for the disposal of your estate. So what does that all mean? It all means that one, stuff is going to happen to you during your life. And estate planning is going to help you figure out how to manage that stuff that happens to you during your life. And how to manage all the assets that you have, all the things that you own during your life. So it also helps you if something happens to you while you're still alive, but maybe you're in a coma because you've been in an accident, or maybe you're in the hospital for an extended period of time and you're not able to make financial decisions for yourself. That also falls under estate planning. And then the one part about estate planning that most people are familiar with is the stuff that happens after you die. So that's when the will comes into effect. Okay. So I wanted to first explain estate planning, that it does involve, everyday people, and it is something that everyone should think about. But estate planning falls into two areas: the stuff that happens when you're still alive and the stuff that happens when you die. So
okay, so I got a quick question on estate planning. When you're thinking about that, does it, is there a time when you say, hey, everybody should be thinking about it, or, it's not until you get, over 50 is when you should start really thinking about estate planning, or, is there some rule of thumb to that?
Well, there's really not a rule of thumb as far as age-wise, but there is a rule of thumb as far as the assets that you're accumulating. So as soon as you start to make some money, as soon as you start to accumulate wealth, like a house, a car, anything of value that you want to control, that's when you want to think about estate planning.
Okay.
Estate planning also is about, like, if you have children, right? If you want to protect your children and how your children are going to be taken care of, either if you're incapacitated, hospitalized for a long time, or after your death. That also falls under estate planning as well.
So I have I'm sorry, I got another question too, because you started off great. So I think, and I think we talked about this kind of backstage, but a lot of people feel like, we've had people pass away before, and it just goes to their kids, so why do I need to hire a lawyer, go through this estate planning process when, maybe the misconception is that it'll go to my kids, and if I pass away before, and I still have young kids, then they'll just go to, my parents or my siblings. How do we kind of assist people through that process? Why is it important to go through this and not just leave it to what happens when you're gone?
Well, that's a great question, and that's really the question that most people ask when they think about the cost and the time that's involved with coming up with a will and doing estate planning, because they think that, well, I've always done it this way. My kids are going to go to my parents. My bank account's going to be there. My brother or sister are going to take care of all that. Well, that's only if there's no fight. What if there's an aunt out there and they want to fight you on who gets to raise your kids? Or if there's a brother out there who says, that's my money too, I put some money in there, you can't have that. Or alternatively, if you don't have a plan to tell people what you want to do with your stuff and how you want your kids raised, then the state comes in, Texas comes in and says, this is how the law says we're going to do this, and this is how we're going to have it done. So you lose all sorts of control about how you want things done, and then you lose control about who gets to take care of your kids.
Okay, that's good. Good. All right, keep going. That was great.
So then the arrangements manage your life. This is when you're still alive, and this is when you still have control over all your stuff. So these are the documents that will help you during that time. The statutory durable power of attorney, the medical power of attorney, the directive to physicians, and the Hipaa authorization. So I'm going to go through each one of them separately. These things are documents that, as you're alive, and if something were to happen to you and you're not able to make decisions for yourself, these are the documents that would come into play and help you, help the person that is your, they call it the attorney of fact or attorney in fact, your agent, to help make these decisions for you. So the first one is called the statutory durable power of attorney. It's a document that most people know. It's a power of attorney that assigns the rights of your rights to another person as your agent. They step into your shoes and they can make financial decisions. So with this document, they can go to the bank and withdraw funds or have access to those bank accounts. They can go into financial transactions on your behalf, like sign leases or sign other contracts for you, make a house purchase on your behalf, or sell a house on your behalf, or sign other documents on your behalf. Anything that's financially related, you can check on this power of attorney. There's a little check sheet, and it has a list of items that you can check to see what powers you're going to give this agent.
So when would I start the power of attorney? Like am I getting sick, or do I start early and say, hey, 30 years down the line or whatever, I want to designate this person as my power of attorney? Or is that something that as I get closer to where I start to see maybe my health is failing, then I would want to decide who the power of attorney is?
those are really great questions because there's a two-part answer to your question. Your question is really two parts. The first part of your question is about when you should sign or execute a power of attorney, right? And then your second question is, can I delay that power of attorney, that agent's authority, until later on when I actually need it? So the first part is, yes, you can start this power of attorney anytime you want, but you have to be careful because once you sign this document, you've handed and you say that this document is effective immediately, then this agent that is named on the document can use that document to make all these financial decisions for you and have access to all your financial information. You can also, for the second part of your question, delay the authority and say that this agent can only have authority over my finances at this certain time period or when this happens, when I'm incapacitated. And within that power of attorney, you can also say you have to have a physician, to sign a notary, an affidavit that says I'm incapacitated. I'm unable to make these financial decisions. And this physician signs it, it gets notarized, and now you can have that power of attorney kick in and say, now you are authorized to use this power of attorney. So that was a great question. Thank you. And then so then the next document is your medical power of attorney. That's similar to the durable power of attorney, except that it only covers all of your medical decisions. So this document only takes effect if, one, the doctor has determined that you're incapacitated in some way, like you're in a coma, right? And then two, once that's been determined, that only takes effect over decisions regarding your medical needs. So if the doctor needs to talk to the agent that has your medical power of attorney to ask about treatment, to ask about whether or not you want to continue treatment or what type of treatment, that's what the medical power of attorney will have power over, is just over your medical decisions.
So I have another question. So if I've not done this and I have not designated a person as my medical power of attorney, what does the law say is the next who would it give authority to if I have not designated the person?
If you are married and you have a spouse, then your spouse would be entitled to make those medical decisions on your behalf if you're incapacitated. If you are a minor and your parents would have that authority. If you have a legally appointed guardian, the guardian would be in charge of making your medical decisions. However, if you're just in a relationship with someone, boyfriend, girlfriend, or you're just living together, cohabitating, then there is no medical power or no authority to allow those people to make those medical decisions for you. That's the sad part of it, because sometimes parents don't know what their adult kids want, and it's the adult kids who have lived with their partners for a long time. Those partners would know, but the partners without this medical power of attorney would not be able to make any of those medical decisions.
I think that's huge too. You really said something right there. So I hope everybody's out here listening, because that's exactly what happens. Is that your parents, you're living with someone else, and something happens, and that other person feels like they have a right, or so that would be the same when it comes to the assets as well, right? So if I'm living with somebody and I don't have this arrangement or this set up, and we've gotten a house together, or maybe I've gotten a house and they would think that some of those assets would go to them, but it would not.
That is correct. Yeah. Yeah. So then the next document is called the Directive to Physicians. So that's what you would fill out if you were looking at a terminal illness. You had maybe 6 months to live. The Directive to Physicians would outline how you want to live during that 6 months, what kind of medical care or what kind of medical activity you want the physicians to undertake to keep you alive or to maybe gently send you off. There are very specific choices and options in there. You can, there are check boxes, or you can put in specific language to tell the physicians how you want your last days to um, to happen.
Okay, that's good.
And then the last document is called the Hipaa Authorization. So HIPAA stands for Health Insurance Portability and Accountability Act, and it was a law that was passed to protect your private health information, so that, you know, somebody off the street can't come into the ER, the emergency room, and ask for your information and say, you know, oh, I know Sarah, or I know Kelly. You know, Kelly was brought in here. Which room is she in? Well, they're not allowed to tell you which room she's in. You're in, because that would be disclosing personal health information, right? The reason why you need this form is because in order for a person to have medical decisions made on your behalf, in order for you to use the medical power of attorney, and in order for you to enact and enforce the directive to physicians document, you have to be able to have access to medical records. So the person is named in your Hipaa authorization should be the same person that's named under your medical power of attorney.
Okay.
So that that person will be able to look at your medical records, will be able to discuss with the doctors, the nurses, the treating facilities to make decisions on your behalf. So you'll be looking at stuff like x-rays, prescription medication, you know, treatment protocols, all sorts of things like that. Without the HIPAA authorization naming that person on it, the doctors, the treating facilities, nurses, no one can talk to them, to that person, about any of that information, because it's protected under the law. So all these documents are for arrangements to manage your life. You're still alive at this point. So you're still alive right now, but something's happened and you need a little help. So all these documents together will help you while you're still alive. Now let's talk about what happens when you die. Normally people talk about estate planning is just mainly wills, but wills don't really take effect until after you die.
Okay.
So you can make a will up, write it up, and it'll just sit there, right? And nothing happens until you die, and that's when the will's power comes alive. But the will's power can't come alive unless you bring it to the court, and the probate court gives it life. It gives it life by going through a process called probate. Probate is when.
That's a question, because that's good too. So if I write something,
Okay,
and I put it underneath my bed, and and then I die too, and somebody finds it, is that is that a sufficient document to say to the courts and to the family that this is what this was my wish?
Well, it depends. So it depends. So there are certain things about a will that has to be in the will in order to be valid, right?
Okay.
So a valid will has to be properly signed. It has to be properly witnessed. It has to be notarized, and it has to have certain language in there that'll help cut down the cost of probating the will. Now you can go online, and there are a lot of the LegalZoom and I think NOLO law. They all have these wills that you can just kind of cut and paste and then put in your information. However, that's only for very simple wills. And if you have no other issues with extra kids that are outside the marriage, or you have lots of assets that you want to take care of, or anything complicated, you wouldn't want to use any of the forms that are up on the websites. You want to actually talk to a lawyer that does wills and estates. And you're welcome to call me or talk to me at Law Office Tu Nguyen. But yeah, and just so that you know, what you said about your example of just writing something down and then putting it under your pillow, that actually is a will too. And if you have all those things that I mentioned, as long as you wrote it all in your handwriting, so there can't be anything else on that piece of paper, anything typewritten or anything. You can doodle as long as it's in your handwriting. All of it has to be written in your handwriting. And then you have to make it known that it is your last will and testament, that you're revoking every other will that was out there. Texas doesn't require you to date it, but it's a really good idea to date it in case
Okay.
ever someone who comes out and says, that's not his will, I have the will. So then the will that is the most current will with the most current date is the one that wins. Okay.
Wow. Okay.
So you can actually just sit down and say, I, Tu Nguyen, of sound mind, living in Dallas County, Texas, do declare that this is my last will and testament, and I revoke all other wills and testaments and codicils, and I do attest that this is my will.
Okay.
If you say something to that effect as one of the required language, then that can be your will, and all of that has to be in your handwriting.
Okay,
So
we got a quick question. I'm gonna show it up here. It says, if something happens to both parents, how do you make sure a certain person gets custody of your children where no one can fight or dispute it?
Okay, that's a great question, and that is a custody question that falls under family law as well as estate planning and wills too.
Okay.
If both the parents die, is that without a will or with a will? Because I can answer both questions.
Let's go with both. Let's say
Okay.
there's no will, then let's say there is one.
Okay. Without a will, what happens is the state will use statutory language to appoint guardian ad litems, which I'm also a guardian ad litem too. And what they'll do is they'll go and they'll do an investigation to see where the kids would be best suited to live. And then the courts will determine based on a hearing and several other reports to see where the kids will go. That's without a will.
Okay.
With a will, you can designate in the will a guardian for your kids. And the guardian will have the say-so in how your kids are raised, where the kids live, and all sorts of authority that oversees your kids. But that's with the will, and you go to court, and the court will sanctify that. They'll say, yes, you're the guardian, and here's the paperwork. You can have control over the kids.
So let me ask you something, because you said that the guardian they take the role of the parent, so they can because it didn't make me think that the guardian would take the kids. So, but they can decide if the kids should go with someone else?
Well, usually when people appoint a guardian, the parents, if they have a will and they've written up a guardian language in the will, usually the parents wishes that the kids will go live with that guardian.
Okay.
It isn't really someone who the parents say, well, we're assigning you, Bob, and then Bob, you get to decide who's going to take care of the kids. It's usually Bob that takes care of the kids.
Perfect. Okay, great. Thank you.
And then the other document that is basic to arrangements to manage your death is the appointment for disposition of your remains. So when you die, you either want to be cremated or you want to be buried. Most people nowadays, they buy the funeral insurance, and the funeral insurance will cover the costs of burial and all that stuff. But this form helps you to tell the person that's in charge of your remains how you want to be either cremated or buried. And then the cost of it can come out from the will, from the estate, or the cost of it can come out of the funeral insurance if you have any.
Okay.
Those are the two.
Another question. And so for those of you that are out there listening, thank you, Nucleus, for dropping in your questions. If you're out there listening, please drop in questions and we'll try to get those answered as best as we can. But I did have a question as it pertains to your wills or your will and debt. So, I know that a lot of times what happens is that families, and I'm not, so forgive my ignorance, I'm not fully sure everything that goes in a will, but I know a lot of families still have debt that has to get paid. And is that something you would write in the will, or if you because I think sometimes people think, okay, well, if I'm going to give my house to you, you get to have the house, but what if there's liens and other things on the house? How does that work?
Well, then you'd say, well, thanks for giving me all this debt.
So you basically would incur that debt. Oh, that's terrible.
No. What happens in the will is the will set up an administration. So an executor will be appointed to oversee all of the estate. The estate includes all your assets, all your debts. And what happens is the will language will say, all right, executor, you're in charge of all my stuff.
Okay.
And first off, you have to use whatever money is in my estate to pay off my debts. That's the first thing. The second thing is that you have to locate and make sure all my beneficiaries, all my heirs are notified that I've passed and that there's stuff that may go to them.
Okay.
If there are liens or mortgages on, like, say, a car that you want to pass down in a will, or say a piece of land, or say real estate that you want to pass down, it's still owned by the bank in some form or fashion because there's a note on it. What you're doing is the executor will have the authority to contact those lien holders and tell them that there's a new beneficiary named under the will, and some banks will do what's called a transfer of title.
Okay.
So they'll transfer the note, and the new person that inherits this item will execute a new note and will either assume the note or execute a new note under new terms.
Okay.
Right? So it's like you're either refinancing the home or you're just going to assume the current loan. Or if it's a car, you're going to assume the car note or you're going to refinance the car note. If it's a piece of land, same thing. You're going to assume the terms or you're going to refinance under new terms. So the reason why it's important to have it in your will is because the executor will be able to contact those people, and then you'll be able to coordinate all of that in a couple of transactions, so that you're not going off and doing all sorts of things in too many different ways.
Okay. Perfect. Thank you.
Now, I already told you about how to manage your life, and then I told you about how to manage your death, but I'm also going to tell you one other tidbit of advice. That was my last slide. Okay. One other tidbit of advice is that you don't actually have to go through the probate court to whenever you die to take care of your assets. Sometimes certain things like insurance policies, certain things like retirement benefits, certain things like bank accounts, if you designate them using the forms that are provided by those creditors, you don't have to go through probate, and all that stuff can just go straight to your beneficiary. You just name those documents. Probate sometimes is hard because, one, it's time consuming, depending on how complex the estate is, and two, it costs money just to go to court.
Okay.
Both in court fees, because you have to file stuff, and then in attorney's fees, because the attorney has to spend time to go to court. The other thing is, if you have an independent administration, which means that once you go to court, the court says, all right, administrator or executor, you take this document and you go do this stuff. You find everybody, you go do it. You don't have to come back to court. That's independent administration. It's a lot easier, because the other alternative is dependent administration, which means you have to go to court each and every time to ask for permission to do stuff. So you have to go back to court if you need to sell something. You have to go back to court if you have to distribute something. You have to go back to court to ask for permission for every little thing. And that costs time and it costs more money. So that's why it's important, regardless of how much stuff you have. You should really talk to an experienced attorney to really understand what your needs are, and then they can go and give you advice on how to tailor that, how to tailor a will or how to tailor an estate plan for you.
Okay, so I have another question. What would you say, if any, are like common mistakes that people make when it comes to estate planning and wills? Like, what are some of these pitfalls that we probably should try to avoid?
Well, for estate planning, it's just not having those basic forms I went through. Those would be, I think, the most basic things that you should have, especially if you haven't talked to your parents for a while and you're a grown adult and you're living with somebody. You want to make sure that that person is the person that's in charge of all your stuff if something happens to you. That's the main thing about estate planning. The second thing would be a pitfall for wills is that you're putting stuff into a will that really doesn't need to be in a will. Those examples that I gave are the retirement accounts or the insurance policies that have beneficiaries that are named. Those things can't be in a will because those are contracts and they have designated people that are gonna get that stuff. And it doesn't fall under the estate code or anything like that. And then the final thing that I see people make a mistake on is that they have too many copies of these things floating around. Okay. Once you have like a power of attorney, you don't want that document to be handed to everybody. You just want that one person to have it. And then if ever you feel like you have a beef with that person, you want to be sure you take it back. You want to tear it up.
Tear it up.
You want to make sure they don't have it, because if they have it, they have all your business. They have all your. And then for a will, you want to make sure that you control the version that you have the limit that at least one other person besides yourself knows where this will is located. Because if you die and you don't tell anybody, it's got and it's under your mattress or your pillow, it may not be found for a long time. So your stuff is going to be sitting there for a long time, or they may make a mistake and go through intestate administration, and the state of Texas gets to decide what happens to your stuff. And that may not be what you want.
And if that happens, there's no way to kind of, reverse that later.
Well, there is a way to reverse it later as long as it's done within the 4 years after your death. However, just like a bell, once you ring it, it's a lot of work, a lot of effort, a lot of time and money involved to unring that bell.
Yeah. That's really, really, really good. Okay, so you talked a little bit about what you should never put in a will. And then the other question, we talked about starting early. So I wanted to know a little bit, like some people feel like the process of hiring an attorney and that this is super costly. And so, what would you say? Is it super costly, or do the benefits outweigh whatever the cost is? Or is there a reasonable financial way to get this done?
Well, that's an easy answer because you're talking to me. And I'm an attorney, and I'm going to want to be paid for all this stuff. But all jokes aside, it's very reasonable. And my advice to all my potential clients is that you have an idea of what you want before you talk to that attorney. You gather all your documents together. You make sure that you understand what it is that you're focused on. A lot of times, sometimes people call me up and they'll just start talking about their legal issue. And I really have to spend the time to really listen carefully to what it is that's really bothering them. If you can go ahead and be more organized with your documents and be more organized with what it is that you truly want, then that attorney will be able to focus in and use that time more efficiently to give you what it is that you need.
Okay.
Sometimes that's really the time constraint there. As far as how much it costs to file with the court, and then how much it costs to go through probate, that also depends on the complexity of the assets that you want to probate as well. So if your will is very simple and it's validated and it was properly executed and it was done correctly, then the will itself, uncontested, should take about 4 to 6 weeks. Okay. And usually the court fees are about $500 to $800, and the attorney's fees are on top of that. And sometimes attorneys will do what's called a flat rate. Well, they'll just say, you know what, this is uncontested. You have a valid will. Let me just push this through the probate court for you, and it's not going to cost that much.
Okay.
Maybe $1,000, $2,000 or so. Sometimes it's even less. Under the Dallas Bar Association's Entrepreneurs for Community Lawyering, which is the program at Sanford, Holmes and I are trying to promote. There are a lot of attorneys in there that will do a much less amount of money for probating a very simple uncontested will, and it won't cost you thousands and thousands of dollars. However, I have seen where some uncontested wills become contested, and that can run into the thousands and thousands of dollars. You have to know what you have to begin with.
And when you say it becomes contested, that means that there's another family member or someone else that says you don't have the right to do this?
Well, that's partially true. There's two parts to that. There could be another family member that goes and has an issue with the will itself, where you're claiming that, Kelly, you get the house, and nobody else gets anything else. Kelly gets all of it. Mm-hmm. Somebody else comes in and says, no. I remember talking to mom, and mom said that Kelly doesn't get all of it. She has to share with me. That's contested, right?
Okay.
The other part of contested also could mean that it wasn't a valid will, that something happened along the way where maybe the person who died wrote the will in their own hands, but they didn't execute it properly. Mm-hmm. And you can't find the witnesses to go to court and say, well, I can testify that this is Kelly's handwriting, and I can testify this is what Kelly wanted. That's when that becomes a contested will, and it becomes a little bit more time consuming, because you have to have court hearings to come in and have people come in to testify whether or not the will was valid and whether or not it was executed properly.
Okay. So, and then now I'm just being nosy. Is that something that that happens a lot? That somebody would contest, even if it's a well, written will, and it seems fair. I'm just surprised that somebody would contest that. Is that something that you see pretty much that happens more often?
Well, you'd be surprised. This is a heated situation. Lots of people, you've just lost a family member. Now, all of a sudden, you learn that there's money involved. So it's heated. People are going to fight over. I've seen people fight over dogs and cats and rings and maybe even books, because sometimes it's a sentimental value that is more important than the dollar value that's on there. So whatever it is that they feel is important, and they think that they're being not treated fairly, they'll contest it.
That's good. So, and I think too, and we have another question that I'm gonna go to in 1 minute, but I think part of what is also important is really just the forethought, like thinking ahead. To me, even when you said, I think a lot of us, especially if you're on the younger side, you're really not necessarily thinking about this. But even what documents to pull, and I think a lot of times it's left to the family after you're gone to try to find, all these documents that you have. And, I just think it's really good for us to be thinking ahead and saying, hey, I'm going to pull this stuff together and have it all prepared and ready, and not put that pressure. You just said, you lost a loved one, and then now this loved one has to dig through all your stuff to try to find out what accounts you had and what, I think that's just a lot of extra work that I think that we could be preparing for our family members.
And I wanted to point out one thing about protecting generational wealth. Yeah. I think a lot of families nowadays, they have this home and they've been passing it down through their generation, and this home has increased in value, especially in areas of the city where they see a lot of growth. And you want to protect that. You want to make sure that grandma's home, grandpa's home gets passed down to and stays within the family. So that's why it's important to have an estate plan, and it's important to have these documents in place.
That's really good. Really, really good. Okay, so we got another question that says, I've seen families argue about having more than one power of attorney. Is it better to just have one?
I'm going to give you a simple answer. Yes. Never have more than one power of attorney. So I'm going to assume that this is the statutory durable power of attorney, which is something that governs the finances. This is
Okay.
not about the medical power of attorney, which governs medical decisions. Because most people, when they ask about a power of attorney, they're really asking about the financial power of attorney.
Okay.
And you definitely do not want to have more than one durable power of attorney, because that person there is going to go on a shopping spree on your behalf. And I've told, especially my more senior clients, when they are worried about their health and they're worried about whether or not their bills are going to be able to get paid if something happens to them, and I tell them, be careful who you give this power of attorney to, because they can go and empty your bank account. The bank doesn't have to pay you. The bank will tell you eventually, because they'll send you a letter that says, thanks for doing business with us. We're sorry to see you go and close your account. But yeah, with this, it's a very powerful document. You only want to have one, and you only want to name one person, and that person has to be someone that you truly trust.
Yeah, that's good. That's really, really good. Okay, so is there anything else as you think about, and so guys, we're coming to the close of our time with Attorney Tu Nguyen. So if there's anything else, I want to give you guys a few more minutes to ask your questions. This is prime opportunity. And so, not often do we get to have an attorney and answer questions, and she's not charging us tonight to do it.
I want to also tell you that, because I also do government benefits, I also want to tell you that power of attorney is very important if you have government benefits. You want Social Security benefits, SSI, SSDI, anything, Medicare, Medicaid, all of that stuff is going to be accessible if you have a durable power of attorney. That person is your agent. They can go and talk on your behalf to those agencies so that those benefits don't get stopped, or there isn't a problem with the benefits just because you're incapacitated. You're not able to call up those government agencies and make sure that they're paying you. All of that's important as well.
But actually, I really, I hope everybody was listening, because that's huge. I've really seen just in recent with family members trying to contact and and people are like, who are you? And you're trying to help your mom, and she's not in a place where she can get that information and assist, but you're not the specific person. And I think that's really huge, what you said, not just with government, but even with bank accounts. You're trying to contact the bank, and and they're like, who are you, and what connection what connection do you have to this? They're protecting the person, but I've seen people just really struggle trying to get, especially dealing with government and government resources, and really trying to really struggle to get what they need for their family member. So really, really great. Anything else to tell us just one more time just about your law office and how people can contact you?
Okay, well, I'm the founder of the law office Tu Nguyen, and you can contact me on my website, www.lawofficetn.com. You can also call me, 214-531-4250. And I welcome any time to help and serve the community.
That's great. Can you say your number one more time? You said 214.
214-531-4250. That's not my personal number, but it's an office. It's an office number that will accept text messages. So if you feel more comfortable texting, you can also text to that office number as well.
Awesome, awesome, awesome. So I want to thank you. I felt like that was super great information and definitely taught us a lot. And so, so guys, if you are, which you should be, I feel like what we walk away with, and when we gain knowledge, we want to apply that knowledge and do what's best for our families. And so please contact the law office at TN. As you're thinking about wills and estate planning. Thank you, Nucleus. And if you miss this, you can always contact Victory, and we can get you connected with Attorney Tu Nguyen. So thank you guys for sticking with us. And this was our second session of Victory's Legal Clinic. And so again, thank you to our resident attorney tonight. And so we really appreciate her. And so thanks, guys, and have an awesome, awesome evening. Bye, everybody.
Bye.